Good evening. This is John Milburn for Laws 11059. This is Statutory Interpretation. We're in week 2 of Term 3, 2017. Tonight we are dealing with the notional topic of the creation of legislation. I think it's a pretty easy topic. I think you've covered that in Introduction to Law. There's a lot of material in the study guide. There's some good commentary in Samson, and there's some very good material online. So I'm going to cover what we're supposed to cover fairly quickly and then get into some other material that I think is perhaps more interesting. The usual rules apply. If you wish to ask a question, please use the chat facility, or even better still, unmute your microphone and ask. If you're not speaking, I will get you to mute the microphone, and we're all doing that at the moment, so thank you very much. So let's share the screen, and hopefully you can see the second study guide, second week study guide. Is that what's coming up on your screen? If you just give me a nod, I'll take that as a yes. Great, thank you. All right, so the creation of legislation. Let's move through this fairly quickly. I take it that you all know that legislation is created through parliamentary process. I suspect that you have a good understanding of that process, and if not, look at the Office of the Queensland Parliamentary Council website. It will provide you with some very good shorthand information using flowcharts. Sometimes it's overlooked. The Legislative Standards Act of Queensland, for example, is something for you to consider. Obviously, we need to understand the difference between the bicameral and unicameral systems of government that we have in the Commonwealth and in Queensland, respectively. Other states have bicameral systems. All of our parliamentary lawmaking power is sourced through constitutional power, both at the Commonwealth and state level. When it comes to the Commonwealth Constitution, I think the starting point is Section 51, not 52, 51. And there are certain presumptions that need to be followed, certain rules that need to be considered. Again, I'm moving very quickly because I expect that you'll be able to follow this material pretty easily, and you've got other material that you can consider. There are certain drafting guidelines that you should consider in the context of Parliament making laws. And if you look again at the Office of the Parliamentary Council, you'll see some worthwhile statements about how those guidelines are followed. Also, there is the handbook that you can access through the government. Make sure, of course, that you consider the Act's interpretation acts, both Commonwealth and state, when dealing with issues to do with the interpretation of statutes. And bear in mind that there are some drafting conventions. So when you read legislation, when you're considering how legislation comes into existence, think about those drafting conventions that apply, and we've summarised those for you in the textbook. Again, I'm sorry I'm moving so quickly because I've got other things that I want to cover. Parliamentary process, have a look at the website for the Australian Parliament House, and there are some very good comments there. Yes, Deb?
Just letting you know, you are dropping out really badly tonight.
Oh, is it? Again, I'll try to speak as clearly as I can. Thank you for that. Can you hear me now? If I speak a little bit slower?
No, I think what it is it happens when you share your screen. You're on a delay of at least 3 to 4 seconds.
That bad? All right.
Yes.
Well, I'll get around that by not sharing the screen so much. But thank you. Is this a little better?
Yes, it's fine now. I seem to notice it the other night when you're on the share screens as well. So.
Oh, okay. Thank you. Thank you for letting me know that, because I wasn't aware of that issue. I had planned to share the screen, as I often do, a few times tonight, but I'll do that selectively and carefully. As for now, I'll invite you to, well, not literally right now, but you can read through the study guide yourself And I'm sure you can read that study guide just as intelligently as I can read it. So there's no need for me to spoon feed that to you. If you do have any questions, follow up with some questions on UCrew. And please feel free to invite a response to a student's concerns or questions. Don't wait for me. And I know that you'll do that. Right, so are there any questions at this stage? Oh, there's a lot of comments about broken audio, and hopefully that's a little better now. Right, any questions in the meantime? Comments? All right, thank you. Okay, let's talk about where we're going with this subject. If we look at the overview for the term, we note that the first assessment is due on Thursday of week 5. That is the 14th of December. It's likely that in week 5, I won't have a live session. That's to allow you an opportunity to get your assessment done. So what I plan to do, and I do this occasionally, is pre-record a session to camera dealing with intention and interpretive techniques, which is the topic for week 5. But I'll let you know closer what it is that we're actually doing. But I just earmarked that that's likely to happen on this occasion. So the first assessment, which deals with a number of issues, research task, legislation, case question, is due in week 5. I expect that you would have done all of your reading up until week 5, including week 5, in order to answer the assessment. So that's why I'm going to bring forward, I propose to bring forward the online session so you can view it earlier. In order to answer that question, or indeed any statutory interpretation question, I think you need to have a plan. In answering legal questions generally, you'd all be familiar with IRAC: issues, rules, application, and conclusion. But when it comes to statutory interpretation questions, I think we need more flesh. I need to give you further guidance so that you can specifically focus on the issues that relate to statutory interpretation. So this is the part of the lecture that's not in the study guide that I really want to convey to you tonight. So, when we think about the specific focus from statutory interpretation, I think about some core skills and I think of some other skills. If you like, the core skills are requisite skills, and I'm going to identify 3 of them. You might like to take a note of some of these things because it may be that when you come to structure your answer for a statutory interpretation problem, you can use these as headings, not necessarily formally, but in your own mind or your worksheet. I don't necessarily expect that you will have these as headings to problems. They probably won't work in that way, but it will give you a guide or a template if you like. So what are the 3 requisite skills? Well, the first is that for a statutory interpretation question, you must be able to locate and then use legislation. That's one of the core elements. And that's really what we're covering tonight: creating legislation, researching legislation, finding it. That's number 1. Number 2, once you've found the legislation, in order to interpret it correctly, you need to apply the aids, or you need to be aware of the aids to interpretation. So during this course, we'll talk about statutory interpretation aids. So thinking about the aids is the second requisite skill. The third is you need to deploy or apply those interpretive techniques which come about as a result of considering the aids to interpretation. So once you've identified those 3 core or requisite skills.
Sorry, could you just repeat that third one, please, John?
Yes.
A bit. Can you just describe that a little bit better? Thanks.
I'll use a phrase. You need to deploy interpretive techniques. Okay. So the special skills. Beyond those core skills, what do you need to do? Well, typically a question relating to statutory interpretation, which is a problem question, relates to the exercise of executive power and a question as to whether or not the statutory power conferred on the executive has been exercised validly. Put another way, you need to develop a skill of determining whether the exercise of a statutory power is invalid. How do we do that? Well, you can ask yourself whether a condition for the exercise of the power has been breached. You can ask yourself whether there's any procedures regulating the exercise of that power has been breached. That's one special skill. The second special skill is, does the law have a retrospective operation? There is an allied question to that, and that is, what was the law at the time of the purported power being exercised under the statute? So you need to ask yourself, or have the ability to determine whether a law has retrospective operation. And secondly, an allied question to that is, what was the law at the time of the purported exercise of the statutory power? That's, if you like, the second special skill. The third special skill is determining whether a statutory offence contains a mental ingredient that prosecution needs to prove. And Gary's identified for the second point, does that allow for amendments? Perfect. That's exactly the point that I was trying to make. Thank you, Gary. So that's the second special skill. The third special skill, does the statutory offence contain a mental ingredient that prosecution needs to prove? We call that mens rea, M-E-N-S, new word rea, R-E-A. Some people pronounce it differently. And if so, if there is the mental ingredient, what is that ingredient? Are there any questions at this stage, comments?
Is the mens rea applied particularly to criminal law?
Yes, criminal law and quasi-criminal law. So when it comes to statutory interpretation, certainly from my perspective, I tend to draw on my experience and teaching in environmental law, consumer law, things of that nature, where there are offence provisions and there's a grey area as to whether or not the statutory offence is committed in circumstances where there is a mental ingredient that needs to be proved or not. And you have to sometimes work out whether or not that mental ingredient is a requirement for a successful prosecution. Now, the fourth is, these are the specific powers or specific skills. The fourth is determining the scope of the statutory power to make delegated legislation. So very often when we're talking about statutory interpretation problems, we're dealing with issues to do with the executive, and it might be, for example, a counsel, prosecution or compliance issue. That counsel officer is working typically under delegated legislation. You need to be able to determine whether the statutory power was properly conferred on that body to make the delegated legislation. In other words, is the officer purportedly acting under a properly conferred power? Again, you won't need all of these for every matter, but they're things that you can keep as a checklist, as a guideline, and it may give you, if you follow these rules, it may give you a source of inquiry and an approach to answer a problem that might initially stump you. Look, the fifth one, the last special skill, is to determine whether there are any rules that may apply to the statutory interpretation problem that relate to a Charter of Human Rights or a Bill of Rights, things of that nature. We'll talk more about that. I will expand on these things. I know they probably sound a bit abstract at the moment, but we'll just expand on it shortly. So these are the things that you as a law student need to consider in properly giving an appropriate answer to what is the meaning of a legislative provision. In other words, what is the correct approach to the interpretation of a statute? These are things to consider. Right, let's go through those 3 requisite skills. Number 1, locating and using legislation. That's what I'm supposed to be talking about last week and tonight, but I think you've got that covered. If you don't know how to locate or read the legislation or find out the explanatory notes, the memorandums, the statutory, the second reading speech, then ask through UCRU and we will collectively help each other. But can I take it for the moment that we all know how to do those things? All right, good. So that's the first requisite skill. Number 2, we need to consider and apply. Well, number 2 is we need to know the aids to interpretation. So now I'm filling in some of the detail that I glossed over before. So can anyone give me any examples of aids to interpretation?
Explanatory and memorandum?
Yes, that's a source of material, but it's not so much the aid that I was looking for. Deb says past cases. Yes, that's part of what we look at to determine certain aspects of the aids.
Would it be extrinsic material?
Yes. Now that's exactly one of the things I was looking for. Another one is purpose. Yes, but that's part of what we're looking to do. Actually, what we're trying to do is find the aids that help us to determine the purpose. Iraq, not so much. All right, let's go back to
definitions. Definitions in the legislation.
Definitions are an example of an intrinsic aid. So, thank you. That was Tanya. So, Tanya, what you've given us there is an example of what David identified in a slightly more general approach, and that is intrinsic aids. So, when we're interpreting legislation, we need to consider the intrinsic guides to interpretation, which are found in the text of the legislation, and definitions, Tanya, is most definitely one of those things. Other intrinsic guides? We talked about these last week, so I'll gloss over it fairly quickly. Objects clauses, definitions clauses generally. The headings give you an idea of where we're going for these things. For the older pieces of legislation, it might be a preamble as well. Okay, so you know where we're at with this. Just to recap, we're talking about the second requisite skill, which is talking about the aids to interpretation, and we're going to identify 5 of them now. We'll expand on this as we go through the course, but it's to give you an overview of how to answer a statutory interpretation problem. Number 1, you must be familiar with using intrinsic guides found within the text of the legislation as the first aid to interpreting that legislation. Number 2, what I've got in mind is number 2, what I've got in mind is number 3 is what you'll probably tell me right now. Given that I said intrinsic guides is something that is an important aid to interpretation, you'll probably say extrinsic materials, but we'll deal with that as number 3. Number 2 I've got in mind is this. Courts, and someone did identify cases, Deb identified cases. Courts will work on certain presumptions. They'll work on certain principles. So in order to properly interpret legislation, as an aid to doing so, you need to understand the principles and the presumptions employed by courts. we do that by reference to past cases, generally. So that's number 2. That's the second aid to interpreting legislation. The third is we have a look at extrinsic materials. And there were a few good answers there. People said, have a look at the explanatory notes, have a look at the explanatory memorandum, have a look at the second reading speech, things of that nature. But when you're considering extrinsic materials as an aid to interpreting legislation, think about it from the perspective of the common law and the rules that relate to extrinsic materials at common law, and think about the statutory regimes that deal with how we use extrinsic materials as an aid to interpretation. So that's the third aid to interpretation, extrinsic materials. Number 4, Bill identified this exactly, spot on. You want to tell us, Bill? The Acts Interpretation Act. Now, when I say act, singular, I really mean plural. I really mean, of course, the Commonwealth version and the Queensland version, or the version whichever state you're in. So the 4th aid to interpretation is to look at the Acts Interpretation Act itself. The 5th is just generally other contextual factors that are authorised by law. So that might be treaties, it might be, in some instances, it might even be secondary materials, writings of learned scholars, etc. Okay, so when you're thinking about the first skill in interpretation of legislation, you've got to find the law and you've got to be able to use the legislation. The second skill is you must be able to know, you must know what the aids to interpretation are, and then you can think about applying them. Which leads me to the third key or requisite skill, and that is, how do you apply or deploy these interpretive techniques? Well, how do you do that? Let's be more specific. Again, I've got 5 points here. The first is, when you read the legislation, in order to interpret it, it's very likely that the provision is open to more than one construction. I mean, otherwise it wouldn't be part of the problem, would it? I'm not going to present you a problem that it just has one possible interpretation. So you can almost count on that. So when you're considering the question, ask yourself, is it open to more than one construction? When I say construction, I mean interpretation. But we use that word construction very often in law. Number 2 is, okay, if it's open to more than one construction, what are these alternative constructions? And you must not only identify them, but you must articulate them. And the construction that you put forward as an alternative must be reasonably open to you. It can't be fanciful. So there must be some basis for saying, this is one way that the provision could be constructed. Here is the second way that the provision could be constructed. And here's the reasons why there are 2 versions open to you in this case. Now, let's say there are 2, maybe there might be 3. The third task in deploying the interpretive techniques is to resolve the competing alternative constructions. So at this stage, you're going back to the aids, those 5 aids we talked about, in order to resolve the competing constructions. And then you must, number 4, come up with a way that the construction that you say is correct can be accommodated within the existing text of the legislation. I mean, you've always got to go back to the text of the legislation. And then number 5 is you come up with a reasoned view as to the legal meaning or the likely legal meaning of the doubtful provision. So that's really the counterpart of conclusion in IRAC. So what we talked about just then is the third requisite skill, deploying these interpretive techniques. If you have this ready to go, it'll help you to answer the question. So I've been talking now, I've just been expanding on the three basic skills, but you'll recall that I said that there are some special skills that you need to consider. Let's go through those just again. You'll have them written down. Number one, was the exercise of the statutory power invalid because something had been breached? Does the law have retrospective operation? You'll have this written down already. Third, related to mens rea and the mental ingredient to be proved. Number four, determining the scope of the statutory power. And number five, applying the rules of interpretation as they might relate to a Charter of Human Rights. So, if you like, those special skills can stand aside from the requisite skills, or they can be used as part of determining those requisite skills. I hope that's not too confusing, but it's meant to give you some focus on how you answer the questions. Are there any questions? Oh, good question from Gary. But you need to deploy in a manner that suits your argument the best. Exactly. There is nothing wrong with forming a conclusion and then working backwards to justify that conclusion. There is a rider to that. You can't mislead. You can't ignore relevant law for the sake of being convenient. So if you're arguing a statutory interpretation matter in front of a judge, you can't cherry pick. You need to identify the relevant law. But within that context, you can certainly deploy in a manner, to use Gary's words, that suits your argument the best. I like that phrase. That's good. Thank you, Gary. Okay. All right. So what I tried to give you is, in some ways, a summary of the entire course, because each week we will talk about intrinsic, we'll talk about presumptions, we'll talk about extrinsic, we'll talk about applying those things, we'll talk about statutory offences, etc. So it's a bit of a rundown of what we're going to do. Now, when you're writing your answer, you need to give a reasoned opinion as to the appropriate meaning, justifying your position. Now, I mentioned that you can consider any applicable Charter of Human Rights. Do we have any Charters of Human Rights in Queensland or Australia? What do I mean by a Charter of Human Rights?
We don't have a Bill of Rights, do we?
We don't. No, we don't. But does that mean that there's nothing you can rely upon if you wish to argue for a certain interpretation of a statute supporting that? Yes, sure.
We're members. Haven't we signed the Geneva Convention for Human Rights? So I guess if there was like a refugee case or something, you could go along those lines?
Yes, exactly. Now, very good. So we look at international treaties and obligations. Going back, I guess the start would be to look at the Universal Declaration of Human Rights. That was proclaimed by the United Nations General Assembly in 1948. It was really a milestone document. And if I could share my screen with you successfully, I would take you to the Universal Declaration of Human Rights, because I've got it on the second screen, but I won't attempt to do that. You'll just have to keep looking at me and listening to me for a bit longer. But find that. It's easy to find. The Universal Declaration of Human Rights, have it handy, because if you're going to mount an argument based on human rights, you've got to support it with something. David's right. We don't have a Bill of Rights, certainly in Queensland, but you can go back to those more general principles. But there's not just one. We're a party to a number of human rights treaties, and I say we being Australian. So others that you could consider would be the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social and Cultural Rights, the Convention Against Torture and Other Cruel, Inhumane or Degrading Treatment or Punishment, Convention on the Rights of the Child. There's 3 more. The International Convention on Elimination of All Forms of Racial Discrimination, Convention on the Elimination of All Forms of Discrimination Against Women, and the Convention on the Rights of Persons with Disabilities. If you want to find a good source of information, I'd had it ready to go, but go look at the Victorian Equal Opportunity and Human Rights Commission. They have some excellent material and they have some good commentary about these international obligations. So that's the Victorian Equal Opportunity and Human Rights Commission. That'll give you some good guide. Now, Gary says Articles of War. Not sure about that one, Gary. Do you want to elaborate? No? Okay, just an idea. I'm not saying it's not there, it's just that it doesn't come to mind. So why am I telling you about human rights? Well, the reason is that when we look at those special skills that we were talking about, it was the ability in interpreting legislation to draw upon these more general principles if it supports a particular argument for you. Okay. So what then is the aim of statutory interpretation? We've worked out a map or a game plan for what we do to interpret legislation, but ultimately what's our aim? We talked about this last week. If we go back to almost, well, it's over 100 years now. Dixon and Todd, 1904, 1 CLR 320. The High Court said the aim of statutory interpretation is to determine and give effect to the intention of Parliament as disclosed by the language of the statute. How do we determine the intention of the Parliament? We look at the words, having regard to the common law and the statutory rules of construction. And if we want support for that proposition, you can cite Wilson against Anderson, 2002 213 CLR 401. I mentioned this, I think, last week. More recently, the High Court, Lacey against the Attorney General, 2011 242 CLR 573, which talks about properly identifying the statutory purpose in the context of the intention. And you can do that by looking at extrinsic materials, explanatory notes, second reading, speech, etc. Now, technically, there is a difference between intention, purpose, object, and motive. I'm just going to ask you to do this. Write down those 4 headings: intention, purpose, object, and motive. And as you progress through the semester, try to fill in some material to say what those things mean and how they are different. Because when it comes to an exam question or a question about statutory interpretation, there may be subtle differences made of you when we talk about, with reference to the purpose of the legislation, explain this. Or what was the motive behind Parliament introducing this legislation? So in order to know those, in order to pick up on those nuances, you need to get an idea of the difference between intention, purpose, object, and motive. Does anyone want to give me an idea of what they might be? I'm putting you on the spot so you don't have to worry. I'm giving it to you as homework to fill in the gaps as you go. Anyone want to have a guess at the difference between those things? All right, well, I won't tell you. And even if I did, it's only my opinion. But start to fill that in for yourself. All right. Okay. So Sean's given us some further information. If anyone interested, H.V. Evatt was an Australian lawyer famous for his work at San Francisco Conference. Really interesting. Thank you, Sean. That sounds like something that would be great for you crew as well. Now, we know from our discussions last week that the modern approach is the purposive approach. You will come across the things we discussed briefly last week: literal rule, mischief rule, golden rule. I don't want you to get too hung up on that. I'd really like you to narrow in on the purposive approach. One of the key cases, which is for your assessment, is CIC insurance against Bankstown Football Club. And the relevance of that case is that the High Court, I suppose, if you like, created that modern approach in that it related to the purposive approach. And reading from the case, the quote was, "The context of an act is to be considered at first instance and not merely at a later stage when there is some ambiguity, and context is used in the widest sense to include the existing state of the law and the mischief the act was intended to address, that is its purpose." There's a hint as to what we mean by purpose right there in that quote. Did you pick up on that? Okay. All right. So that's the type of approach generally that we need to look at. I think a couple of really good cases to look at initially. You certainly need to look at CIC in Bankstown. You'll need to do that for your first assessment piece anyway. And look at Project Blue Sky. That's an important case which you will need to refer to often. I really want to share my screen here, but I know it's going to cause all sorts of problems. So let me just see what I can do. All right. Maybe you could try screen sharing. Yeah, we could maybe give it a go. I'll just continue for a bit longer. So we know the first assessment. We know roughly what's involved in that assessment. Everyone's read it, I take it? You've got to go. All right. So a question on you, crew, I think today. Thank you for that question. The legislation must be enacted in 2016 or 2017, not current at that time, but enacted earlier. So it's got to be a new act. And this first question, which relates to the research task, is really designed to cover the first of the express requisite skills that you need, and that is to locate an act and understand the act. So that's what we're trying to do in that first question, deal with that first requisite skill. But it's a pretty easy task. Second is the case note, which deals with the application. Again, that's a really quite a simple task. I don't think you'll have any trouble at all with that first assessment. If you do, don't stress over it. Just ask in your crew generally, and I'm sure that you won't need to wait for me to give some guidance. There'll be others in the class that are happy to assist. Okay, let's be a little bit more specific and talk about the sources of law in Australia. I think we know legislation and case law, they're the primary sources of law. Don't worry too much about the secondary sources of law. If I refer to your text, at page 16, Michelle Sanson makes a really good observation, one that I hadn't actually considered before I read it. And that is that when you're looking at legislation and trying to interpret it, generally you can perhaps give it a category. And that category could be, as Sanson describes it, the fuzzy approach. And this is really borrowing from Justice Rare's, which is where Parliament creates a general provision and then leaves it for the courts to determine the application on a case-by-case basis. Alternatively, to the fuzzy approach, as Justice Rare describes it, Parliament may attempt to provide a very clear and comprehensive statement with minimal scope for judicial discretion. So you can think about that from an overall perspective. Now, when we talk about legislation becoming law, we know that it goes through Parliament, but does that make it law, or is there an extra little step, which is a very important step, that needs to be undertaken before the legislation becomes enacted? It might go through Parliament, but it's not law yet. Assent, yes. And where do we get this assent? Who gives the assent? Governor-General. The Governor-General, in what role? As representing the, starts with
Queen.
the Queen, yes, but the word we use is the Crown.
Yeah.
Okay, so we're on the right track. Well, if the Crown needs to assent to the legislation to make it law, can anyone tell me where we look to determine the date for the commencement? I mean, is it necessarily going to be the date of assent? Or can it be different to that? We know that the assent is a necessary step, but
From what I was reading, if it
Yeah, sure.
wasn't, it's like 28 days after. Isn't there a law that it starts 28 days if there is no set date for when it assents?
yes, sometimes 28 days. Sharon says 14 days in Tasmania. You're certainly on the right track. So in order to understand when the law becomes effective, we know that we need to consider the process of assent by the Crown. Yes, Sarah?
It's specified differently in each jurisdiction, but it can also be specified within the legislation if it's to be on the day of assent, if it's been backdated, if it's to start at a certain date, if it has a sunset clause. Such things are included within the actual legislation, and then each jurisdiction has its own general provision that it occurs at a certain point after assent.
I like that answer. I like that approach. And it is important because, you know, people that, law lecturers who write statutory interpretation problems, they just love to throw in a little trick, don't they? That, you know, an act went through Parliament on a certain day, something happened on a certain day, royal assent occurred on a later day. You know, did the statutory provision apply? If so, why? Things of that nature. So you need to understand this process of the Governor-General assenting on behalf of the Crown, and you need to look at the legislation because it will have, as Sarah correctly described, issues about when it takes effect. And bear in mind that in the legislation, not all of the legislation will immediately take effect or take effect at the same time. It's possible for different parts of the legislation to take effect at different times, even though the legislation has received the assent. So you look at the legislation itself, find where that is, and that's another reason why you look at all the headings. You look at the legislation generally before you drill down to the specific provision. Now, Sarah correctly said, but there are some general provisions. Certainly Sharon was onto this, Sean was onto it as well. What's this 28 days bit, 14 days bit? Where does that come from if it's not part of the specific legislation?
Isn't it if there's no date of assent anywhere in that particular act that it's then 28 days from the date of assent?
We're getting very close.
And
So yes, sorry, Tanya.
That's okay. I was going to say, and then is it in the Acts Interpretation Act that then tells you that?
That's exactly right. That's exactly right. Thank you. But bear in mind, as we said earlier tonight, there are Acts Interpretation Acts for each of state and territories. that apply for that state and territory, and there is the Commonwealth Acts Interpretation Act. Commonwealth version from 1901, the Queensland version from 1954. Now, both have had substantial amendments. So you need to consider, within the context of looking at the Acts Interpretation Act, when that section came into effect, because the act that you're talking about may predate that amendment. So it kind of becomes a bit convoluted. So let's say Queensland. An act does not contain a date of commencement. You then need to consider the Acts Interpretation Act. That will tell you the effective date of the act coming into force. We know that it's linked to the date of assent, but is it the date of assent? And what's the section of the Acts Interpretation Act of Queensland that gives us the answer?
Section 15A.
Spot on. Very good. Thank you, Tanya. 15A. Now, it's not 28 days, though. It's the date of assent.
Yeah.
Okay. So how do we determine the date of assent? Do we phone the Governor-General? Sorry, just wondering when you actually got round to assenting to this one. Or is there some other way of doing it? Where would we go to find the date of the assent?
Would it be on the Parliament website where the legislation is?
Yes, exactly. Go to the Parliament website. That will go to the Queensland Parliamentary Council website, have a look at acts as passed in a particular year, and you'll see the date of assent there. I mean, there's probably a few places you can find it, but that's where I would suggest you go. So you get the picture that if you're answering a question about statutory interpretation, you need to consider all of those aids that we've discussed tonight, but you then need to consider those very practical questions about when did this particular provision come into effect and how can I prove that if called upon to do so. So in Queensland, have a look at the Act, as Sarah says. If not, as Tanya correctly identified, look at the Acts Interpretation Act, Section 15A. And then, as I think Tanya said as well, go to the Queensland Parliamentary Council website to look at the actual date of assent. All right, Commonwealth. It'll come as no surprise that the same rules apply. The same default legislation applies, that is the Acts, the same named Act, the Acts Interpretation Act applies. 1901. What's the section relevant and what's the timing?
Section 3A2, and it's 28 days after the date of assent.
Spot on. Thank you, Tanya. That's it. So it's slightly different. We were close when we were talking about 28 days. So the basic default rule in Queensland is if there's nothing in the Act, 15A says it takes effect on the day of assent. Commonwealth, if there's nothing in the Act, it takes effect 28 days after the date of assent. And that's Section 3A, subsection 2 of the Acts Interpretation Act, Commonwealth. Okay. Bill says, what happens if the Governor-General refuses to give assent? It's an interesting question. I guess it won't go through. We might have a constitutional crisis. Suddenly, for those of you that are a bit older, you're thinking 1975 in a different way. All right. I'm not sure I know the answer to that one. I'm not sure it's actually happened, Bill, that I can recall.
Wouldn't that be a constitutional dilemma in terms of the mandate of the people? If the Governor GG was to refuse that because he wasn't really directly democratically elected?
Yes. Again, that's the same issue in a different context that occurred in 1975, isn't it? I think the older ones will know what I'm talking about.
That was when the Governor-General kicked out the Prime Minister, wasn't it?
Exactly.
I just saw recently there's a whole heap of new information coming out that John Kerr may have acted completely out of line, and there was a lot of cover-up between him and Malcolm Fraser within those dealings.
Look, that may well be the case. I'm not sure we want to go there in a statutory.
Wasn't the official version of that incident is that a bill was passed in the lower house, went to the upper house, was denied, went back, and then because of this constant stalemate, they what was the word? Disbanded the government at the time? Yeah.
It was a supply bill. It bounced back twice. The Governor-General then said the government couldn't effectively run. The government couldn't effectively function without funds. So therefore, it. Now, what is the word? You're right. It starts with D. Disassembled. That's not the word, but that was the effect of it. Anyway, dissolved. Thank you, Marcus. Yes, that's the word I was after. Dissolved Parliament, and that we had the double dissolution. Anyway, we digress. I don't want to digress too far. So we know we need to look at the Acts Interpretation Act. Do we have a good idea of why those sections are relevant, when they come into play, why you must consider that, and always consider the timing of it? All right. Time is moving on, but I'll just really quickly say this. There is in law a push to plain language drafting. Simple drafting to make it easy to read. It's harder to write in simple language than it is to write exhaustively. But legislation historically was lengthy and exhaustive. Drafting now using minimal language creates a problem. And that problem is that if previous legislation is rewritten in plain English style, how do you convey the same meaning but do so in a way that avoids ambiguity? Have a look at section 15C of the Acts Interpretation Act.
Is that not the bit that says that if a statute has been redrafted to plain English and there is no mention that it is meant to say or mean something different than what it was previously translated to mean, that it means the same thing even if it uses different words?
That's it. Yes, that's it.
Is that 15AC?
15AC, Sean. Yeah, did I say 15C?
Yeah, I was just checking.
It is 15AC.
I got it wrong.
No, that's correct. That is absolutely correct. So what I'm going to ask you to do is, for the homework, is to look at that section and consider the case of Commissioner of Taxation against Stone from 2005. Look, if I've got a couple of minutes, I just want to share the screen. I'll just try it again. This will be my last attempt. We'll see how it goes tonight. Because I wanted to make this point in the context of sharing the screen. Now, can you see the Federal Register of Legislation? I hope the lag is not too bad. I've linked you to section 15AC of the Acts Interpretation Act. But you'll note that I haven't gone directly to the section. Now, you'll know that that's what you do. You don't look at the section directly. You look at the headings, the context. You get a feel for the Act before you start to look at the section. So that's why I took you to the top of the Act, the Acts Interpretation Act. From there, you can make your way to section 15AC, but you do so after you've considered, for example, the table of contents. And you'll see the table of contents, and I've just blown that. The table of contents includes Part 5, which deals with general interpretation rules. If we go to Part 5, you'll see that Section 12 on, for a while, includes Section 15AC, which is the section we're talking about right now. So the point that I'm trying to make by that exercise is to ensure that when you consider looking at a particular section of an Act, you do look at the Act and the headings to get an idea and feel for it before you jump in. All right, that might do us for tonight. Are there any final questions before we wrap up? You've been very patient. All good? All right, thank you very much. Okay, well, I'll end the meeting now and we will see you next week. All the best. Bye.